Guys. The Honorable Justices of the Supreme Court, this court has recessed, now sitting.
Thank you, everyone. Please be seated. This begins our 10:30 docket this morning. Mr. Shima, would you please call the 10:30 docket?
Thank you, Your Honor. May it please the court. The first case on the 10:30 a.m. docket for Monday, December 15th, 2025 is appeal number 128574, State of Kansas versus Terry D. Horton Jr., appeal from Wyandotte County.
Good morning. May it please the court. I'm Joseph Desch. I represent Terry Horton. We are present and ready for argument.
Good morning, Garrett Ralph, representing the state of Kansas, Deputy District Attorney out of Wyandotte County, present and ready for argument.
Second case is appeal number 128161, in the interest of K.R., a minor child, appeal from Reno County.
Good morning. May it please the court. Candace Burgess for the appellant N.A., present and ready for argument.
May it please the court, Jamie Karasak, Assistant District Attorney, Reno County, representing the state of Kansas, present and ready for argument.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Shima. I will now call the case of State of Kansas versus Terry D. Horton, case number 128574. Mr. Desch, you may, once you get settled, you may approach the.
Thank you. Again, good morning. May it please the court. I'm Joseph Desch. I represent Terry Horton. This case is well briefed, as you can say, and I'm going to try to avoid going through those arguments again. I have every time I've looked through this, I keep saying the same things as I said in the reply brief. So I'll try to be cognizant of that. This is a felony murder case in which it's alleged that Mr. Horton shot and killed Printara Jackson in the course of an aggravated battery against Cedric Scott. As I said, I could probably talk about this case for hours, and I imagine so could Mr. Ralph. But luckily, we only have 30 minutes to do this. The trial featured secondhand accounts of several ghost witnesses, people who didn't testify, including the alleged victim, Cedric Scott, also absent with the responding officer who spoke to Scott, the woman who provided assistance to Scott at the scene, whomever removed him from the crime scene, Scott's named sister, who allegedly provided information to the lead detective, Tim Fowler, about Scott's injuries and medical treatment. Unfortunately, these actual witnesses were substituted with the uncorroborated testimony of Tim Fowler, who testified for everyone in the state didn't or couldn't subpoena. In fact, Fowler was so.
Can we start right there?
Yes, sir.
And I'm just, I've looked at this case and I'm challenged by what happened at trial, just in terms of what you just talked about, kind of missing pieces, just in terms of direct testimony. And I went back and looked. Officer Tompkins, who's the really, if he was there to testify, there would be no problem with the hearsay, double hearsay, that kind of thing. I just don't understand why he didn't appear. Where I look at what probably was the defense theory was that your client wasn't there. And what better evidence to substantiate that than Officer Tompkins' observation, or what he thought, at least what he maybe heard, what he didn't hear, but that was never tested. Do you have any, I know you're not trial counsel, but do you have any explanation as to why? I understand Scott they couldn't find him, but what about Tompkins? Why wasn't he there? And why didn't defense? And I know the burden isn't on the defense, all that, but why wasn't he there?
I agree 100%. I cannot offer anything other than they may have expected him to testify because of his importance in
Look at
identifying.
the subpoena, I mean. Okay.
I'm sorry, I can't.
I just,
Speak for
and you
yourself.
try to imagine maybe there was some trial strategy, maybe Tompkins had some explanation as to what the interaction was or something like that. They wanted to avoid it, but I don't see how you get around any of this, that your double hearsay objection, any of that, because of the absence of either Scott or Tompkins. I see your arguments, but I don't, go ahead and address them.
I do have an answer for that, Your Honor. The thing is that instead of having that officer testify who witnessed a lot of things, you actually saw the ghost witness, Cedric Scott. You actually saw what happened as far as after a shooting occurred, or if a shooting occurred. The state didn't want him there because he could give a statement that the alleged victim said Tanisha Horton did it. So the state did not want him there. And I do not know why trial counsel did what they did. Unfortunately, we're dealt the cards we are dealt when we come on appeal. But I will suggest there was one problem with the hearsay objection, or the hearsay problem. The judge limited that availability, or that hearsay exception, to one rather than the three that were available. She said, okay, this is an excited utterance of Cedric Scott. It's admissible if you bring in Tompkins. Well, I would suggest that because Detective Fowler testified in the affidavit and in preliminary hearing of those statements, that should have come in under two different sections, under 460A and 460C. Now, 460A.
Let me just ask you,
Sorry.
that wasn't argued at trial court.
It was because it was cut off. He did actually try to bring in Fowler's prior statement by offering the affidavit of charging. Now, I'm not sure if the preliminary hearing was argued or not. I don't believe it was. But as a testifying witness at preliminary hearing, they could have allowed it under the fact that it was an impeaching, it would be impeaching information with respect to Detective Fowler. He said one thing in preliminary hearing, and then at trial he said shooter, which was not proven at all. That would have definitely been evidence of prior statement that is contradicted in the test by the trial testimony.
Do you have any case that suggests that an arrest warrant affidavit is sufficient to satisfy that reliability prong of hearsay? I couldn't find it.
I do not. All I can tell you is that it's a sworn affidavit, and that leads to the second argument, that it's a sworn affidavit, which might be covered under 6460C as a prior testimony or prior affidavit of a party that's testifying at trial. So beyond the hearsay, beyond that, if you consider the fact that other hearsay statements were allowed through this witness from other witnesses because of those, because of 460A and 460D and, in fact, also 460C, is it not a fundamental fairness argument that if you admit some hearsay from a witness that's testified from a ghost witness, shouldn't you be able to also admit other hearsay evidence from that same witness that's not there, the ghost witness? So, but as far as that goes, I think that's about what I can say about the hearsay argument. I believe if the judge had not cut off argument and not kept him from going there, he could have trial counsel could have got where he needed to under 460A. Now.
And can you remind me, I'm sorry, I don't have it in front of me. I assume the defense was there's an identity question, right? Who the shooter was. It was your client charged as a principal only. There's no aiding and abetting.
Exactly.
Okay.
Exactly. He was charged as a principal, in the fact that, well, he was charged as a principal saying he was the shooter.
Right.
And that shooting somehow occurred because of an aggravated battery that happened to another person. In the 6 seconds he was off camera. I'd implore you, please watch those 3 videos and see if you come to the same conclusions or presumptions that Fowler did. Now, I'm not asking you to reweigh the evidence. I'm asking you to determine if there is evidence to support his conclusory testimony.
Well, I looked at them numerous times. Why isn't there?
Well, I'm sorry.
Why isn't there conclusive evidence, not conclusive, but strong circumstantial evidence to support the conclusion?
There's no gun. There's no gun whatsoever. There's a shadow. There is no gun.
There's a shadow. There's, you can kind of see at a certain time, the suggestion that he's tucking something into his pants. All of those, while fuzzy, couldn't a jury reach those conclusions?
They could if Fowler did not testify about his conclusions and completely speculative things. Another suggestion, and I'm not trying to, another suggestion is a lot of African-American men like to have their pants down and like to pull them up a lot, or like to put their hands down their pants for some reason.
Well, it appears as if he's holding something, that movement happens, and he's not.
Is it a gun though? Is it?
Yeah, right.
Okay.
Understand.
Okay. That being said, there is no, and I'm going to move on to my sufficiency of evidence argument. There is no evidence whatsoever at trial that Terry Horton shot anyone. There's no evidence that he was actually in such an argument with Mr. Scott that he would have shot him. There's a presumption, there is a speculation. There's just no evidence that he actually participated in the crime.
Yes, there's no direct evidence, right?
That's true. But is circumstantial evidence, can that come out of a vacuum? Can the circumstantial evidence be solely supplied by someone who says, this is it?
No,
This is what I believe.
I watched the video.
Okay. Okay. And I'm not trying
There's
to,
blood on the porch, I
Okay.
mean,
there sure is.
yeah.
Whose blood is that?
Well, again, it's not direct evidence.
Right,
But
okay,
if you put
okay.
together everything,
But
could a jury find beyond a reasonable doubt?
could they, without evidence of him actually doing the shooting, without actual evidence? Oh. Okay. And I'm not trying to argue with the judge, but Justice, I'm sorry. There just is only a presumption based on, there's an inference based on this argument that my client's sister was so angry at this fellow, she had to call her brother, although she carries around an assault rifle with her. Is that not the most ridiculous thing? I mean, she has the guts and the wherewithal to carry an assault rifle with her to this alleged confrontation, but yet she's going to let her brother go take care of the business. That being said, I understand where this court's heading, and I understand that, but I really think that the elements must be proven with some evidence, even if it's circumstantial, has to be some evidence. If there's not some evidence of that, you can't find him guilty because the elements are pretty simple. The elements of felony murder is you got to show that Terry Horton actually killed Printara Jackson. And the killing was done while he was committing an aggravated battery with a gun against this Cedric Scott. You know, Cedric Scott was such a ghost. His name wasn't even right 24 times in the transcript. 24 times. He was such a ghost that he was Cedric Ward. All that being said, again, and then there's the problem of I'll go ahead and move on. The problem of the state shifting the burden in final arguments. Yes, Mr. Horton offered an alibi. It was not complete. He offered that, and in doing so, the state jumped all over it and said, why didn't you tell us this? 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 All those things could have been helpful, but do they have to be? Does he have to give a complete alibi when he's being interrogated? No. And the state can't suggest that he should have given an entire alibi at the time he was being under Hernandez. He can't be required to prove his whole case while he's being interrogated for a murder. Now, the other question, and I'm going to get back to sufficiency of evidence because this is just.
Before you go back
Yes,
there,
yes.
I was just curious, the argument that you raise, that if a court sustains an objection, whether it's in closing or cross, that you're equating that to error. And I'm just wondering if you think there's ever any room for a middle ground where a trial court could sustain an objection, yet it's still room for not crossing the wide latitude of prosecutors given to argue the case? Or do you just think it's, as I understand your argument is you're equating those two, sustaining an objection to being prosecutorial error, the first step of our two-part test?
I'm equating those two because the district court was correct in first part. As to the second part of the question, actually your first part of the question, a court could stop somebody short and say, "Hey, wait a minute, you're getting somewhere you shouldn't be." But in this case, there was a correction, then there was another correction, and another correction, and a fourth one that was, "I've told you, don't go there." And that is the point is, now we're not on the old bad faith or the old standard, which said, if you repeat an argument that you've been told not to do, then that's ill will. We're gone from that standard. But I would say, if you think about it, it really applies. So the evidence, like I said, that actually was proved with some evidence, whether it be circumstantial or not, was Mr. Horton was taken in a light most favorable state. Mr. Horton was there, light most favorable state. What did he do? We don't know. There is no actual evidence that shows he actually shot someone or that anyone shot anybody. With that respect, with that question, you could have suggested, or the evidence would have suggested that maybe Mr. Cedric Scott had his gun and he went and shot Printero Johnson first of some kind of a gunfire, and then Horton walked in on it. Very possible. So at any rate, and I forgot to ask you to reserve 3 minutes or 2 minutes. I apologize.
I did note that from Mr. Shima.
I apologize.
Appreciate that, Mr. Dash. 2 minutes will be reserved. Do you have any other
Any other questions?
Any other questions, colleagues? Thank you.
Thank you.
Mr. Ralph.
Morning, Your Honors. I think, again, this appeal stems from simply a difference in experience of someone who does trials versus attorneys who don't. It appears to be a different assessment as to what is necessary to be shown at trial to prove the elements, or at least to provide enough facts for a jury to determine whether or not somebody committed a crime. With this regards is felony murder. There was more than sufficient evidence to believe that Cedric Scott was shot, that he was shot by the defendant, Terry Horton Jr.
What's the evidence that Mr. Scott was shot?
The evidence that Mr. Scott was shot was that they were dispatched, police were dispatched out to a shooting with two victims, one who was dead on arrival, one who was injured at the scene. That Eddie Scover was also told that there was the security guard of the apartment complex, that there was a shooting with two victims. That when they arrived on scene, Cedric Scott was taken to the hospital. Cedric Scott underwent surgery, and that there was next to where his body was found, there was a pool of blood. There was also a cell phone with a bullet hole in it. That was the same cell phone that he was talking to Tanisha Horton on at the time of the shooting. The injuries on Printero Jackson came from all were on the left side. The shell casings, the majority of were on the left side of where the victims were. The evidence came out that Printara Jackson was facing the stoop where Cedric Scott was found. He was to the left side of the shooter on the video. Cedric Scott would have been to the right side. The evidence was that you could easily infer was that Cedric Scott was shot. Certainly that he was injured in the shooting. And even the scenario that was presented by the defense trial counsel was, well, maybe that he was startled by the shooting of that shooter, who he said was not his client, but maybe he was startled by the shooting and he was injured. That still would have been a person felony. And during the course of that felony, Printara Jackson was killed. So even under the defense's own scenario that they presented in their closing, even if you would have guessed to that, that there was no evidence of that happening, it still would have been felony murder. With regards to the hearsay exception, that it should have been, the statement made by Cedric Scott should have been admitted because of 60-460A. Well, that relates to prior statements that were given when the witness has been given a chance to be cross-examined. In this case, the statement, yes, initially was made by Cedric Scott. It was made to Officer Tompkins. Officer Tompkins then told Detective Fowler that Cedric Scott told me it was Tanisha, my girl, she shot me because I was cheating on her. In this scenario, Officer Tompkins would have had to testify at a previous hearing. He didn't. That was Detective Fowler who testified at the preliminary hearing. So since Officer Tompkins didn't testify at a prior hearing, wasn't subject to cross-examination, 460A wouldn't have applied. It also wouldn't have been for impeachment evidence because it wasn't a different statement made by Detective Fowler. If Detective Fowler had been allowed to testify to it, he would have said, Officer Tompkins told me that Cedric Scott told him that Tanisha was the one who shot him. There's nothing inconsistent about his statements, so you couldn't impeach him with it. And as the appellant conceded, there seems to be no case law that says that an affidavit can just be admitted at jury trial. With that being said, you also had to, if you're even wanting to find that Cedric Scott was unavailable, there does come into question the credibility of the statement. There are two people that the state was able to show with definitive proof did not shoot and kill Printara Jackson. That was Booker Watson and Tanisha Horton. We know this because they were on video at the time of the shooting elsewhere in the apartment complex. You can see from when they enter the apartment complex, leave the vehicle, they're walking around. From the time that the shooting happens and they flee, they never once approached the scene of the murder. So those two couldn't have done it definitively. Not to mention, the defendant testified and said, she didn't do it. She wasn't there. So it would have undermined the defendant's own credibility to then somehow enter in that statement. All it would have done was simply muddy the waters with a statement made by somebody who clearly had an issue with Tanisha Horton, because the testimony was that she and him had been in a fight. He had gotten physical with her. And he made a statement that could not have happened if she could not have been the shooter. I don't know. Maybe he said she did it because he knew it was her brother that shot him and she assumed that she was behind it. Don't know. Again, all it would have done is muddy the waters. Now, with regards to the shifting the burden, the appellant argued that there were 4 times that the state moved to attempted to shift the burden and that the court shut it down again and again and again and again. And through these cumulative attempts to shift the burden, the defendant did not get a fair trial.
Let's just start with why you suggest that the defendant, Mr. Horton, should have offered his explanation as to where he is or where he was that night doing the DoorDash delivery, going to McDonald's and going home. And you say, why didn't he say that? Why isn't that shifting the burden? Why does he have any burden to come forward with an explanation of his whereabouts?
He has no burden whatsoever to come forward as an explanation as
So
to.
you're suggesting that he does, aren't you?
No, not at all. But when he did, when he chose to talk to the police, waived his right to remain silent, he was asked, what did you do after you met with your sister at Grand Sam Liquor? He said, I did 2 or 3 more door dashes with my girl. Then we went home around midnight. He said he didn't know where those stops were. He provided an explanation as to his whereabouts, what they were at the time of the shooting. They were inconsistent with then what he said when he took the stand. The case law does allow for impeaching inconsistent statements once the defendant waives his right to remain silent. And that's what happened here. Now, with regards to what was actually asked during cross-examination, it was asked, when you were asked where you went, why did you not tell them that you went to McDonald's? I didn't think it was important. Then was asked, well, did you think it was important at any time in the 2 years between then and now? Then the objection occurred. They said that that the state was shifting the burden. I believe that the court made the incorrect ruling.
Yeah, what do we do with that? If we believe, you believe made an incorrect ruling, do we then review the court's ruling in sustaining the objection and telling the counsel to move on? What do we do with that?
I think
It's unusual. That typically doesn't happen in these kinds of things, but the court made a ruling. And what's your argument on how we should handle that?
If the argument is to whether or not you should look at every objection that is made and whether it was correct, I don't think that would be a good use of time. I think, frankly, that the court would be inundated with an incredible amount of appeals, despite that the bench probably gets it right a majority of the time. But in this particular case, the defense is saying that it was clearly burden shifting because the court ruled that it was, that they sustained the objection. Well, if the defense is going to use that as proof of burden shifting, then shouldn't it be whether or not the court was actually right? Or you can simply ignore whatever the court ruled and simply look at the facts of the case, the circumstances in which the objection occurred, and the statements that were being made. Forget what the court ruled. Is the appellant correct in that the state was burden shifting? I would argue no, they weren't. Now, with regards to the second one, that objection occurred during the initial close by the state. They said that the defendant refused to provide his girlfriend's name. Objection. Took the stand. The defense argued that it's a mischaracterization of the evidence. He didn't refuse to give the girlfriend's name. The state posited, well, he knew her name. He said he didn't give her name at the time of the initial interrogation, and he didn't give it because he didn't want to. I don't know why refusing was the kicker there, but then with the defense's approval, the state was then allowed to say, okay, he had his girlfriend's name. He didn't give his girlfriend's name. He didn't want to give his girlfriend's name. And the name would have given them the phone number. Then from that, the detectives could have got potentially from the girlfriend's mom's phone number, which is what the defendant said and the girlfriend said the DoorDash account was used. It was registered under the girlfriend's mom's number. At the time, the defendant didn't know what her phone number was. Fair enough. So the detectives asked him, okay, well, what's your girlfriend's name? He didn't give it. That, one, is not shifting burden. Two, is not related to the question about McDonald's. Then the third objection, that Cedric Scott was shot. Again, not burden shifting, but the defense objected that there was no evidence that he was shot. Then didn't object to the state argues a reasonable inference based off the evidence, and then went into the litany of the evidence that suggested Cedric Scott was shot. That was allowed in. The fourth rebuttal, or the fourth objection was during rebuttal that after the defense had given their closing, had argued that the Detective Fowler did an incomplete investigation, a shoddy investigation, that we didn't have enough. The state argued in its rebuttal, well, would have helped the investigation, would have been the DoorDash account, would have been McDonald's video. What the appellant is disregarding is the fact that in the closing, the state had harped on the credibility of the witnesses, all witnesses, and the statements that were made, told the jury, does it make sense? When you have two conflicting reports as to what happened that night, two versions of events, which one of them makes sense? And they said to do that for all the witnesses. They went through the girlfriends, including the girlfriend, who testified that she didn't talk to her boyfriend about this. He had been arrested twice. She knew that. She knew that he was on charge for murder. She never talked to the police. She never came forward. She never told them about McDonald's. She never gave them the DoorDash account. Even still at the jury trial itself, she had still yet to provide that information. Even though she knew her mom's number, she could have done that. She didn't. It was asked, does that make sense? The state has every right to attack the credibility of a lay witness and whether or not they chose to come forward, whether it made sense when her boyfriend is on charge in jail for murder, has been arrested twice for it, that she would not come forward at all. That's what the state did. All four of those objections, none of them were related. None of them were burden shifting, and certainly wasn't cumulative error. Your Honors, at this point, I have no further comment unless anybody has any other questions for me.
Any questions, colleagues? Thank you very much, Mr. Ralph. Mr. Dash, you reserved 3 minutes.
Thank you, Your Honor. Okay, there are a number of things I'm going to probably go out of order because I've made some terrible notes here. I think that my colleague is misunderstanding what 6468 says. The person on the stand can be related back to their prior statement, and their prior statement under oath, certainly. Whereas we're talking about the statements of other people that were not sworn and were not used in the same way. Okay. As far as your time goes, Terry Horton has 50 years to think about this, at least his whole lifetime. In fact, his whole life, period. So I would not ask this court to not waste its time, but I don't think it should consider its time any more important than Terry Horton's life.
Well, I think we would all agree with that. How do we address the issue of whether or not the district court erred in sustaining the objection? When you read it, I'm not sure the judge was sustaining the objection other than saying, move along, do this. And then he also mentioned they gave kind of a cautionary instruction at one point. What do we do if we don't think it was burden shifting? Some of these arguments and the judge got it wrong.
Well, I don't think that the state preserved it with an objection at the trial court. They had to make their point and preserve that objection. I don't think they did that. I do need to move on. I'm sorry, because I have a very short amount of time left. Question also becomes, did Terry Horton have a gun going into that? Where was this showing that he had a gun? The evidence was, no, he didn't. No, he didn't. And nobody knows. The person that supplied the majority of the lay witness testimony was Booker Watson. He said, no, he didn't have a gun. Only one that had a gun was a handgun was Cedric Scott. Now, let's see. As far as Mr. Horton's testimony testimony versus his statement, he issued a general denial and said, hey, I wasn't there. That's it. general denial, hey, I wasn't there, I was doing this. I don't think he has to offer any more information than that. Now, had they asked, that'd be different, but the police didn't ask that. Now, they did ask who his girlfriend's name was, but he wanted to leave her out of it. So what? I mean, he has a right to say what he does or doesn't want to say and when he's being interrogated. This sounds a little bit like the telephone game too, as far as the hearsay goes. The state's allowed to play the telephone game, but the defendant's not. Does that make sense? Well, if this officer said this to this officer who said this, who ended up testifying about what the first officer said about the declarant. So that being said, isn't it fair that the defense should be able to do that same telephone game strategy if part of that statement was admitted under the state's case? I still would like to say, well, I'm out of time. If I could have another minute, please. The witnesses, Eddie Scover at trial said nothing about the crime. The second witness, Siobhan Watson, or Siobhan, I don't remember her last name, I'm sorry, said nothing about the crime.
Didn't Eddie Scover identify Mr. Horton?
He did not at trial. At trial, he said, no, I don't know who that was. And in that prior, he was only put on the stand so Mr. Fowler could tell what he thought he said. Really. And that goes the same for Mr. Watson. His statements at trial were far different than what he gave to the detectives. And the detectives were able, this particular detective was able to say whatever he wanted to about what Mr. Watson said with no repercussions of whether it's true or not. I think we had a detective that did this kind of stuff named Golubsky. And when we rely on one person to supply all the evidence in a trial, that breeds error and breeds corruption. And I think that we should be very concerned about where a case revolves around one witness that did not witness anything, that did not witness the elements of the crime. Thank you. Anything else?
Thank you. The next case on the docket, 1030 docket, is in the interest of K.R. Case number 128161. Morning, you may approach.
Good morning.
Good morning. And let me just clarify, you did reserve 3 minutes for rebuttal.
Yes, I did, Your Honor. Thank you.
You may proceed.
Thank you. Good morning again. I'm Candace Burgess with Kansas Legal Services for NA, the appellant, the mother, and may it please the court. The mother is appealing the termination of her parental rights to K.R. And as the court is aware, parental rights are a fundamental right protected by the 14th Amendment in the Constitution of the United States, which cannot be disturbed unless showing that a parent is unfit. And I can give a brief history of the case on this. The child was taken into custody July of 2021. A petition was filed and there was an adjudication made in August of 2021 that this child was a child in need of care. In July 7th of 2022, it was found that reintegration was no longer viable at a permanency hearing. A termination trial was set for August 31st of 2022. That termination trial did not take place, and it was a default decision, an order to terminate my client's parental rights. That order was filed on September 19th of 2022. There was a motion to set aside that default judgment filed. That motion for default judgment was denied by the district court, and the mother appealed that decision on October 12th of 2022. It was reversed and remanded by the Court of Appeals and set back down for a new hearing. The first hearing that was set was to be November 20th of 2023. That actually got continued to January 10th of 2024. That was the first day of trial. The state did their evidence. The mother had witnesses, and so there had to be a second day of trial. That was March 26th of 2024. After that, both the state and the appellant, the mother rested. The father, prior to the first scheduled termination trial, had relinquished his rights, so he was not involved in the hearing. The district court asked for findings of facts and conclusions of law by all parties. Those were submitted, and there was a final journal entry order by the court that was submitted on July 3rd of 2024, and then an amendment to that on July 9th of 2024. The mother appealed that decision back before the Court of Appeals. The Court of Appeals affirmed the district court's decision on July 25th of 2025, and then we petitioned the court, and we are here before the court. We're here before the court. Our petition was specifically on one issue. I noticed the court had in its kind of thumbnail all the issues, but we're before the court here regarding if the Court of Appeals erred in finding that the district court correctly determined that their mother's ability to care for the child is unlikely to change in the foreseeable future, and affirming the district court's decision on that. And the district court made findings on fitness of the mother, and then it proceeded to its conclusion. There was nowhere in there a consideration regarding if the mother's unfitness was unlikely to change in the foreseeable future.
Let me ask you this about that.
Yes.
See if you agree with how the district court approached this. I believe the district court recognized that there were two things that needed to be found. And, so why can't we presume the unfitness was not likely to change element so that, and then the court went on to discuss the best interest of the child and all that. It seemed like, my point is, the court recognized that a finding is required about the likelihood of the unfitness changing. It may not have expressly said it, but it recognized that it's needed to, or that's an element. So why can't we just presume it that, and go on?
I believe the court, and just in a previous decision, said that there's three parts, but there's the first two parts that have to be met by clear and convincing evidence. One, that there's unfitness of the parent, and the second one, that unfitness, that conduct or condition that makes that parent unfit is unlikely to change in the foreseeable future. Did I do that?
Yeah, we're getting feedback
Yeah, someone have a phone on?
from the
Something's
beginning.
picking
that you
up.
started talking.
Yeah.
Oh, are you wearing a hearing aid?
No.
Yeah, something's creating a feedback. I don't know.
And can you turn it down a little bit? Yeah.
What's that?
Okay.
Okay.
No, thank you. And
No, you're
don't
welcome.
worry about your time. You
Oh,
can.
it's okay.
I
Go
guess
ahead.
my point is, this is not a case where the court neglected to recognize the elements of the case. It recognized them. It just didn't make the express finding. And then it went on to make the other determinations. So That's all I'm getting at. Why can't we presume that finding since it went on? It knew it had to do it this way. Didn't say it, but it did go on.
I would submit, Your Honor, that implying something versus explicitly stating it is not correct in this type of case where these parental rights are such a right. It should be noted that a court is looking at each of the steps that need to be looked at and reviewed to make a finding of a parent being unfit, and if that parent's rights should be terminated. And in this case, the court went through, albeit without any of the statutes in the journal entry, went through the unfitness, but basically glossed over about the foreseeable future. And that's why we're here today. We feel like the Court of Appeals affirmed the district court's decision, and we submit that that's an error.
And in fact, the district court found mom unfit for 4 reasons.
Yes.
History of substance abuse. That's definitely not foreseeable future. Failure of reasonable efforts. But failure of reasonable efforts by the agency. So, I mean, here, the efforts, there was no discussion about whether the efforts weren't reasonable, because it seems like it all came down to one thing. She lived in a sober living house that didn't take kids when there are lots of sober living houses that take kids. So that was another reason. Same with failure to adjust circumstances and failure to carry out a reintegration plan when that was all in the past. But the 11 months since the Court of Appeals remanded it, there was no reintegration plan, right? They didn't allow any visits.
No.
And their reason was because, oh, well, you can't be in at the sober house. But she can go to work. She could go be somewhere to have visits with her children. But there was no any plan at all during that 11 months once it was remanded, right?
That's correct, Your Honor.
So is there evidence to support the finding that implicitly was made that that it wouldn't change in the foreseeable future? Is there any evidence?
I don't believe so. My argument at the trial was that we were basically sitting in foreseeable future. She had been clean and sober for over a year. She had been clean and sober since she testified was December 16th of 2022 when she was arrested, and she did testify to that. She had been gone through miracles and successfully completed that. She had stayed 1 month, I believe, in a halfway house before she got into sober living. She testified that she was in the sober living she was living in to save more money so that she could get a car, which she had purchased. And she had it in somebody's yard because she still had to get, and she testified, a driver's license, an interlock device, and her insurance. And the driver's license and such cost $600. So she was having to save.
And did the caseworker or DCF or the adoption worker or anybody try to help her by, getting those things done?
No, Your Honor. No, not at all. They had no contact with her.
No contact.
No. The contact they might have had with her, I believe, was around November, and they testified that they didn't need to see any type of receipts of her work or anything because they basically were not working the plan. She had been employed the entire time. She had, and she also testified that one of the reasons she had picked this sober living place was that when she was ready to have a home, that they would give her a voucher to help with that. And she believed that she would have a home within the next, if she needed a home, she would have it within probably a month. And that was her testimony. She had the plans.
What evidence was there that it would not happen in the foreseeable future? What evidence was presented at the January 10th and March 26th to support this inference that would stay that mom's unfitness was unlikely to change in the foreseeable future at those two hearings. Was
I
there
don't
any
believe
evidence?
there was any evidence. Of course, I'm biased on that, I believe, but I believe it shows that she worked everything that was needing to be worked to be reintegrated with her child. And I don't think there was any evidence. The only thing that it came down to was that she was in that sober living home. But that, as Your Honor has pointed out, that wouldn't have prevented any type of visitation of occurring. And that could have started the reintegration process as she went to get a home. And
one of the reasons for, one of the things they brought up was that it would take even longer because the kid would need to get to know the mom again, even though there was 11 months, that visitation could have happened, right?
right. My time's up, Your Honor. Thank you.
Real quickly, if I might.
We might have some more questions.
Oh, okay.
Thank you.
I take it your position is that when the Court of Appeals at the bottom of page 11 of their decision states that the district court did not incorrectly find that the conditions were, quote, unlikely to change in the foreseeable future. Your position is that Court of Appeals that's just a misstatement of the factual record
Yes,
because there was no finding.
there was no finding about foreseeable future. Thank you.
Any other questions, colleagues? Thank you.
Thank
Okay.
you.
Ms. Karasak?
Thank you. May it please the court, Jamie Karasak, Assistant District Attorney representing the state. First of all, I understand that Ms. Burgess gave you an overview procedurally of what has happened in this case, but what I would like to remind the court is some of the reasons and rationale behind that procedural timeline. So the child was 10 months old at the time that he was taken into protective custody because the mother had left the child with the paternal grandmother at her place of employment with no indication of where she would be.
Well, I don't think, I understand what you're doing, and I don't think anybody disagrees that had that not been a default hearing at that point, maybe it could be supported. But what we're talking about here is in these two hearings and in the district court's decision, what evidence, first of all, the court did not make a finding on foreseeable future and whether there was clear and convincing evidence. But what evidence, I'm going to ask you as I did her, what evidence was there that the unfitness would not change, what clear and convincing evidence was there that unfitness would not change in the foreseeable future?
Okay, so let's jump to that. And what I would like to point out, and the reason starting with why did this case start in the first place? And I think that's important in every child in need of care case when a child is removed from the home. Why was the child removed from the home? And here there were concerns about mother's instability. There were concerns about mother's past drug use that was continuing on.
So how long would she have to be sober before? You're basically saying, oh, we have to go to the very beginning if someone does drugs or if someone's in prison or, whatever it is. Oh, well, that's gonna, 2 years later that we have to always start at the beginning. And, maybe for unfitness, but foreseeable future, I don't understand. Was there what evidence was there?
There was testimony on both sides of that. You had the agency that said, we've been dealing with this child. And as we sit here now, the child is 5 years old. But the child had been with the grandmother and had been working this plan where you first see for about the first year and a half, or longer than that, really. Mother's making no progress whatsoever. There's continued drug use, there's continued instability. And she establishes this pattern of not being stable, of moving from place to place, of leaving places too soon. Her therapist testified that in order for this child to be reintegrated back with her, it would have to be a gradual step-by-step basis because mother in and of herself had more or less sabotaged herself in the past by jumping from home to home or program to program and trying to address her underlying mental health as well as her drug issues. And so there's an established pattern here. Then we have a bit of a different procedural route that this case goes. And so up to the point you have the first termination hearing, or the first termination hearing is supposed to occur, mother has made zero progress whatsoever and has established this solid pattern of instability and drug use, which was particularly harmful to this child. When this child came into custody, he was positive for methamphetamine and THC. So you know that you have these concerns.
And let me ask you this, okay? The child was deemed SINK on August 10th, 2021. The termination hearing, not when they changed it to termination, okay, not when they changed the plan. The goal was changed in July, okay, which is 11 months, okay? So this instability you're talking about for 11 months, the goal was changed in July, and then 6 weeks later, termination. So that's based on not even a 12-month period. But by the time of trial, she'd been sober for over a year.
She testified that she was sober and she last used the day before she was arrested,
Which was
for
December 2022.
That's correct, for drug distribution and for possession. And that case remained pending all through the child in need of
Right,
care
but from
case.
December 2022 to all the way through March 2024, okay? So that's more time than even the first whole thing. This is like 14 months she's been sober.
That was her testimony, and I understand that. And
Was there any testimony to contradict that?
what the agency testified to was during this time up until, so she testified in March of 2024 that they had received no verification of what steps she was taking, what her drug treatment. But the court heard the mother's testimony, and they said, good for you. And everybody said, good for you for getting some stability. But still yet, even at that time, all the way through March of 2024, she had never, along that entire path from July 2021 to March 2024, had been in a residence that was stable and suitable for that child.
Yeah, but DCF stopped working with her, moved it to an adoption worker, and made no contact with her at all, except to visit her home, which they admitted that was the only thing. That if she had moved to a sober living home that accepted kids, we wouldn't even be here.
I think that's a mischaracterization of the testimony that was before the court, because what the St. Francis worker had testified to was, okay, they had a change in phase in the case as the case went along, and it had been in a post-termination phase. Then it moved back, and so the reintegration department was now back involved again.
That's not what she testified. I have the transcript right here. She testified, I don't have this case anymore. Adoption has it.
Yes, adoption had it at that point in time. And then the goal then changed back again to adoption and reintegration reached out and made contact after the decision.
What did they do to help her meet the reintegration plan?
They went and talked to her. They had the first worker talk to her in October, is what the testimony was. The second worker reached out to her in November. At that point in time, mother was not interested in receiving services. They would not allow St. Francis into the home to see
where is that in the record? Okay.
90, I believe in volume 3, page 92, I believe, there's a discussion about St. Francis going there, seeing mom. Mom was saying that she was making sobriety her priority, which was a good thing, but that there was not much that St. Francis could do because she was not interested in working with them on services. She was working with the home that she was in, the sober living home that she was in. And that
so I don't want you to work with me on getting a driver's license, because I drove while suspended. I don't want you to help me find a sober living house that takes kids. I don't want any help from you. That's what you're saying, that this volume 3.
What the worker had testified to was she had talked to the mother about that. Mother did not seem interested in services. And without being able to be allowed into the sober living home, to view to see whether or not even that was suitable, there was very little that St. Francis could do at that point in time, other than keep in contact with mother, monitor the situation to see if the circumstances had changed.
Doesn't all of this discussion, all the contradictory evidence really illustrate what seems to me to be potentially the main problem with this case, which is you're asking us to make a fact finding?
I don't believe so.
Because we don't have a crucial fact finding. Would you agree with that?
Well, I guess I would interpret what the district court's decision and the way that the Court of Appeals interpreted it and said the court recognized what it needed to find, and then throughout its written decision had said that the burden was sustained for that finding in order for termination to occur.
Well, the district court never said that these conditions of unfitness are unlikely to change in the foreseeable future. That's true, right?
The court didn't use that. What the court said was, this is governed by this statute and says you have to make, in order to be unfit, you have to make a finding that they are unfit to, and that is likely or unlikely to change in the foreseeable future.
The court did recite the correct legal standard. Is that what you're hanging your hat on, or is there anything?
Well, first of all, I would say that this is not an issue that was raised before the district court. It was not an issue that was raised before the Court of Appeals. The first time that we see this issue is in the petition for review. And I would point that in the past, this court, particularly in Baby Girl G, which was decided in 2020, the majority opinion there said that addressing an issue not raised to the courts below is against the court's policies. But going to the issue on that decision there, this is the first, if we are objecting to the court's written decision, what the court does is it recognizes what it needs to find, the standard of proof that it needs to apply to that based on statute, and then says that that burden has been met, and then continues on with the third part. So I think that the court did make that finding.
So if you transfer that to a criminal case, if the judge on a bench trial says the elements of burglary are, or whatever it is, here's what the elements are, and it has to be beyond a reasonable doubt. Okay, now I'm going to sentence you to.
I don't think you can translate those directly, because what you have here is we all recognize that there's basically 3 steps that needs to occur. You need to find unfitness, you need to find that it's unlikely to change in the foreseeable future, and then you go to a best interest determination. And what may differ here from, say, a court maybe doing a written decision in a criminal case is a lot of the facts that you're dealing with here in a lot of these cases are going to intermingle, because a lot of these issues, the facts will relate to the different aspects of the case as you go along there. But here, what the district court did was say, I'm acknowledging within my conclusion, what it did was it outlined its factual findings as to the testimony that it heard. It accounted for giving a history of mom's positive progress and negative progress throughout this case. Also noting that, yes, she had a change in behavior when she was arrested on drug charges, and those drug charges remained pending, and applauded her and gave her credit for making those positive changes, but also noted that the court was not going to ignore the past behavior and patterns that had been set up, which is what the agency was testifying to. These remain our concerns. We have a mother here who dropped off her child while being unstable, clearly having a substance abuse problem. As a result, the child was positive, and then had a long period of time of not making any progress. We have the child's case moving on to a different phase in his case. Now it's in the post-termination phase. And during that period of time, mother is arrested, and that's when it prompted her to make these changes. She goes to jail for about 3 months, comes out. As a condition of to get out of jail, she has to go to a treatment. She has to remain sober. She's then in a very structured environment after that. At no point in time does she establish any stable home that the child can be reintegrated into, where you can begin to really work integration. She testified that she had an intention or a plan to move out of sober living, but she also testified that she had fears of that she would be leaving that too early and she would relapse as she had in the past. And the agency shared those concerns. And there was not a solidified plan at that point in time. The court then looked at the overall picture here and the overall history that you have here and viewed it through the lens or the time that you have
I
it.
don't know that, because the word foreseeable future, I did a search, was used once. And that was in the first paragraph of the district court order.
Where it was recognized the findings that had to be made, and then the rationale was discussed as to why the court felt that that burden had been met. And maybe we would be having a different discussion right now had the issue been raised either to the district court or to the Court of Appeals. And there would have been an opportunity to discuss that and correct that, but there was never any objection or request from the court to further clarify its written decision, nor was the issue ever presented.
It's really, at this point, a sufficiency of the evidence issue. There's no evidence.
I would respectfully disagree that there is evidence
Tell me what it is.
with regard to the foreseeable future of what you have here. And it's what I was speaking to. This court has recognized that when you are looking and doing a foreseeable future assessment, that you can consider the parent's past behavior to give you an indication of the future. You can consider that through the time lens of the child's time. And what you have here is, at that point in time, you had a 4-year-old child who had been in state custody with his grandmother at that point.
Out opposing counsel, this was so true. She told the trial court, we are sitting today in the foreseeable future.
And I'm out of time, but I would like to respond to that. So the claim is that on March 24th, that mother was ready to have that child back in her care, back in her home. She did not have a home for their child. She did not have a plan on moving out. She had expressed concerns that if she moved out of sober living at that point in time.
Right, but she didn't have to move out of sober living.
She had to move out of that sober living.
Right, but she could go into sober living.
But she also expressed that if she left, and if she left where she was at currently, that her concern was that she would relapse, which was also a concern of the agency given the mother's history and past. And also the testimony as you go through, there was not a plan to move forward. There was an intention for that. There was not a solidified plan, and it had been 32 months at that point in time. So the district court recognized all of that in explaining its rationale. And I'm sorry that I've gone over time.
No, it's okay. I just have one more query regarding if we find that a specific finding needed to be made here about determination of foreseeability in the future. What happens? I assume we would remand it back for that determination to be made, but would that require a hearing? Would it be kind of where we're at currently or where we were? How would that, in your mind, just in terms of you handle these cases, this is your job in Reno County, how would that, what would happen?
Okay, so I think there's two points of view on that. If you're looking at the precedent here and what decisions have been handed down by the Court of Appeals, or perhaps the only decision I could find with regard to clarifying what needs to happen, what from this court wasn't exactly helpful because it had already found on other grounds and it was an ICWA case as far as we go.
What's the mechanism?
In the past, what the courts have done is not held a new hearing, but remanded it back down for a clarification with the journal entry. However, these cases are different than they are.
They're evolving, they change.
Exactly.
Circumstances now that weren't present when this hearing was held. What happens in that case?
In that case, then I think if the parent wanted to move forward with requests saying that there was particularly relevant information that maybe the court would need to know, because I don't know what the circumstances exactly are here. I believe I know certain things, but that's not in the record. I'm not going to discuss it with the court today. But I think it would be, if there are no further instructions given by a court in a remand, then it would probably, the burden would be on the parent to try and move forward and indicate that it believes the court needs to hear additional information because of the evolving nature of these cases. But in the past, what the courts have done is simply remanded it down, indicating that there didn't need to be a new evidentiary hearing, that the court needed to make specific findings on that. But many of those cases came out when there was a change or clarification, should I say, in the burden of proof.
Okay, thank you. Any other questions? You reserve 3 minutes. And maybe, why don't you start with what relief are you requesting, and how would it be, what would happen should it be sent back?
It would be interesting, Your Honor. If it was remanded back and if the burden was on my client, we would petition the court to involve reintegration. Just so the court's aware, my client is still doing well, very well. And she has followed through with what she told the court she was going to do. It wasn't, it was a plan. It wasn't just an
I'm not asking the
No,
current state,
but
I
no,
want to understand how, if there is circumstances that are relevant to the current condition and future, would that, a new hearing would be held on that question alone?
To be quite honest, I think we're kind of in unknown territory, Your Honor, on that one, at least
I think so too. That's
in
what
my
I'm asking.
practice.
Okay.
Why would the burden be on?
I don't know. I'm not sure if I don't know why it should be on my client, to be honest with you, Your Honor.
Yeah.
And I just wanted to hit a couple of things. I just wanted to make sure the court was aware. My client did follow her plans. She followed them exactly how she testified. And she could have made a mistake, made a misstep, just like she had done before, but she didn't. In this time, she chose to truly rehabilitate herself. And so we're asking the court to look at that the foreseeable future was not looked at correctly in this case. And you can't just look at the past, as this court just had in a recent decision. You also have to look at what is, and I could quote, I guess, Your Honors, but directs the courts to make a forward-looking assessment of whether the parent will be able to care properly for the child.
Do
in
you
the near
agree
term.
that this particular claim was not made in front of the Court of Appeals?
I did not make this specific claim. I made the claim that that all three under 2269 had not been met.
You made an evidentiary claim as opposed to what we've been discussing here, which is that the district court
I
did
did.
not make a finding.
I did.
Does that-
If there is just that specific thing that's sent back down, then the question is, then do I bring it back up again?
Well, my question
For
I
a
guess,
fine,
is
because
that issue preserved for our review?
I believe it is, Your Honor.
And how? How is it preserved?
I believe that Your Honors can look at it under your Rule 8.03B6CI.
Will you tell me what that is?
Well, it states this. It states the Supreme Court will not consider issues not raised before the Court of Appeals, but it also has, there's an exception, which is that the court may address a plain error not presented. And my time's up, Your Honor.
Anything else, colleagues? Thank you very much.
Thank you.
That concludes this morning's docket for December 15th, 2025. Court will be in recess until 9 a.m. tomorrow morning. Thank you all.